For our second problem scenario, we have, again, a couple of different documents here. We have an email and we have a regulation. Effectively, what your client wants to do here is to challenge this regulation before the Court of Justice. So the first question you've got to ask yourself is, which provision of EU law allows private parties to challenge acts of the EU institutions before the Court of Justice? Think about what is required by that treaty article. There are 4 things that are required. The first is that the act must be a reviewable act. Think about what a reviewable act is, look at your authority, but I'm not giving anything too much away here by telling you that it is a reviewable act, but make sure that you've got your authority and you've got your case law to make that point. The second thing that is required is crucial. There are 3 circumstances, remember, in which a private party can have locus standi or legal standing to challenge a measure before the Court of Justice. First, it has to be an act addressed to that person. Again, I'm not giving much away by telling you that this is not such an act. So then you have to consider whether your client either has direct and individual concern, in which case they will have locus standi to challenge the act. And remember to explain what direct concern is and what individual concern is, to apply your authority. Or, if this is a regulatory act, then they need only show direct concern. So take a look again at this piece of legislation and decide for yourself whether or not you think this is a legislative act which requires direct and individual concern, or a regulatory act which only requires direct concern. That's your second step. Your third step is whether or not there are grounds for challenging this act. And I think for this, the first thing you do is look back at your email, and you can see here that your client says, the Commission hasn't consulted on this decision at all. They've given us 0 notice and they haven't explained why they're imposing this tariff. So go back to the lectures, look at the various grounds that are available and decide whether or not you think one of those grounds applies given what you've read in this email. But here's a tip. Make sure you take another look when answering this at the regulation as well, because that will tell you a few different things about the way this piece of law was passed. But the key thing is, I want to see you thinking about what are the grounds for review, identifying potential grounds for review. Whether or not you get it absolutely right or not isn't the most important thing in the world. The key thing is the ability to identify potential grounds for review and try to apply them in this case. The final thing is quite straightforward. Remember, there's a time limit under our treaty article as well, so make sure that you consider that as well. If you consider all 4 steps in a logical, methodical manner, citing your authority throughout, applying any relevant criteria throughout, you should do fine.